Welcome, everyone, and thank you for joining me today for Estate Planning Secrets, how to protect your money and your family and yourself. Hi, my name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. We serve clients in Washington State and in North Idaho. As an estate planning attorney, it's very important to me that my clients understand their estate plan. Well, they're not going to understand their estate plan unless it's explained to them. So my goal today is to help inform and educate you about estate planning secrets. And when I'm using the term secrets, what I mean by that is things that are not necessarily well known or well understood, something that might be hidden and just not a topic, just not information that you would commonly expect to have. So not surprisingly, when it comes to estate planning and elder law, there's a lot of topics that I can choose from to help you understand something which might be a secret now, but should not be. You should know this information. And I will include some gems. By that, I mean some information that, depending on your particular circumstances, could save you and your family hundreds of thousands of dollars in long-term care costs and avoid any type of estate taxes, which is a particular concern here in Washington State, given our low tax threshold for estate taxes. So that's what we're going to be talking about today. If you are joining me live today at this webinar, please put your questions into the chat or the questions and answers. And before we're done today, I will do my best to answer your questions. So feel free to ask questions. Of course, I am not giving you exact legal advice. We don't have an attorney-client relationship, but what I am doing is sharing information that I believe people should know so that they can protect themselves. You know, our goal at ELG Estate Planning is to not just serve our clients, but to educate the public. That's one of the reasons for our YouTube channel. And if you find value with that, just give us a thumbs up or subscribe. We always appreciate that. We are committed to empowering futures. Empowering futures means that we provide the knowledge from which you can take steps to make your life better. So let's get into it. That's what we're going to be talking about today, estate planning secrets. First thing, and this is probably no secret at all to it, is that you need an estate plan. Without an estate plan, you are unprotected should any bad thing happen to you in your life. So I want you to think of estate planning something somewhat like an insurance policy. So you have insurance on your house and on your car and maybe even on your life. The reason that you have insurances on your car or your house is if there is a loss, something bad happens, there's going to be money there to pay for that loss. And of course, if you have life insurance on your death, then the death benefit proceeds will pay to whomever you've designated as your beneficiary. So you have insurance in case bad things happen. Well, an estate plan is kind of like that. If you go through your whole life and nothing ever happens to you to cause you incapacity or any problems like that, you are still facing, as we all are, inevitable passing, death at some point in time. So your loved ones are going to be dealing with your estate. And if you don't have that right estate plan in place, the outcome is not going to be as good as if you had done everything for them, basically put a great estate plan in place. So no secret, you need an estate plan. What's a little bit more complicated is what estate plan do you need? And quite candidly, you are not going to know exactly the estate plan you need based on our discussion today but you will have more information from which you can move forward and talk to your estate planning and elder law attorney. I'm coming to you from Washington State, and what that means is I'm going to be focusing on our laws that are here in Washington. If you live in a different state, much of what I say probably doesn't apply to you. Please reach out to a qualified, skilled estate planning lawyer in the state that you live in. All right, let's get started then. So, some of the biggest myths and misunderstandings about estate planning. And I think one of the biggest is that people think of estate planning as a will. What happens when I die? Because we all know that at the point we die, whatever we have is going to be passed down, we hope, to those who we hope to receive it. So people are thinking about, well, I need a will. And I think that's one of the biggest misunderstandings about an estate plan, because in my opinion, as an estate planning and elder law attorney, and based on the thousands of clients and years of experience in this area of practice, the most important thing you can do for yourself is protect yourself while you are alive through the right estate planning documents. So I do personally think that that's the most overlooked piece of an estate plan. And we are going to spend some time today talking about how do I protect myself while I'm alive through not just having an insurance policy, which of course I highly recommend, but through an estate plan. So what is the one document? And if you've heard me talk about this before, you know where I'm going with this. It's no secret. The biggest, most important document you can have during your lifetime is your durable power of attorney. Why do I say that? And you should have one, and it better be a good power of attorney, because if you have one and it's not a good one, then there's going to be some problems. So let me give you a little bit of context about why I think one of the biggest secrets is that your most important estate planning document is your durable power of attorney. As an elder law attorney, I have worked with many clients and seen how devastating certain illnesses are, especially as people age. And I'm sure you can relate to that if you have helped a family member, parents, maybe spouse. You know, it is not inevitable, but commonly what we see as people age, a decline often in their cognitive capacity. It could be a disease process, Alzheimer's, for example, Parkinson's disease, or it could be something that just, it happens, you know, very quickly. For example, a stroke, which might create the inability for somebody to take care of themselves. So we see this often as estate planning and elder law attorneys. And this, one of the things that I do want to share with you, oftentimes people who won't have put into place estate planning documents are those who are fiercely independent, strong-willed, capable. They consider themselves to be completely in charge of their life. And frankly, they don't want to think, and they don't allow themselves to think about a time when they have to be dependent on somebody else, when they have to trust somebody else to manage their affairs, because it's anathema to them. They don't want to see themselves as not being fully in control, and that's natural. I think that's human nature. But I have to share with you that in my role as an estate planning and elder law attorney, it is very common to see people who were brilliant and capable and, you know, independent have something happen to them and they no longer are. And if they had the foresight or the fortitude, I will say, to get their estate plan in place, to get a good, durable power of attorney in place, they are so much better off than somebody who just put their head in the sand and said, hey, it's never going to happen to me. I'm not going to do any documents. Let me tell you why. Because if that person didn't plan for a day when they might be incapacitated, and it does happen to them, they for some reason, lose the ability to manage their own affairs, and they have not put into place a durable power of attorney, the legal system requires that somebody have the legal authority to manage that person's affairs. Who's that going to be? That is going to be a court-appointed guardian or conservator, and that is through a court process. When I say court process, and I'm talking about who's managing your affairs during your lifetime, and if it's a court process, what that means is that everything about your life is recorded in the court file. There's been somebody appointed as your guardian or conservator. It could be a family member, or it could be somebody you've never met before. It's costly, it's intrusive, it's public, it's complex, it's frustrating, especially for family members that might not be your guardian and some other person is managing your affairs. It is frankly one of the worst situations you could ever put yourself into, because not only have you lost your voice, your ability to speak for yourself, manage your own affairs, but you haven't appointed anybody that you trust to do so. So the state, through the court system, has come in and they have control over what goes on in your life. It doesn't take much of an imagination for everybody to say, I don't want that. That sounds horrible. And frankly, it is. So when you hear of terrible outcomes and estate planning and other things gone wrong, it's usually because there is not a good estate plan in place. And frankly, what I mean by that is a good, durable power of attorney. It is the most important document you can have, your durable power of attorney, bar none. Let me share with you another secret, or something that is not well known and can be very upsetting. If you're married, you might think, hey, I can manage my spouse's affairs if he can't manage them, because we're married. And in Washington, this is a community property jurisdiction. So everything we have is community property. We have both names on our bank accounts. I can write checks. I can pay the bills. I can receive income that comes in. I can do all of that. That is true. But what is not true is the only reason that you have the ability to write checks is because your name is on that bank account. That's the extent of the legal authority you have. You don't have other legal authority to manage financial affairs because you are a spouse. This is a very misunderstood fact, that you as the spouse don't have legal authority. If your spouse loses capacity, loses the ability to manage their own affairs, can you sell your house? No, you can't, because both names are on that deed. Can you look into your spouse's IRA, 401k, change a beneficiary designation? No, you can't. You don't have legal authority. So what do you do as a spouse when your spouse has lost capacity and you need to take legal action because it affects you, not just your spouse? I mean, this is your house and you can't sell your house. How frustrating is that? In the situation where there is not a durable power of attorney, your spouse will be subject to the court-ordered guardianship conservatorship. Will you be that guardian, that person with legal authority? It depends. If this is a blended family, second marriage, the children of your incapacitated spouse may well claim that they are entitled to have a say-so, that they perhaps want to be co-guardians, etc. So you can imagine all of the stress that comes with that type of situation. So don't think that because you're married that you and your spouse don't need a durable power of attorney. I'd say more so than anybody else you do, because of the frustration that would come from one of the spouses having to be subject to a court-ordered guardianship, and they're not the incapacitated one, but they have to run everything they want to do through the court, because you need to get the court stamp of approval for the incapacitated spouse. So not a good situation. Moving on from why spouses need a durable power of attorney, I want to talk about what is and should not be a secret, but not all durable powers of attorney are the same. So you often will see a 1-page or a 2-page document or a form document or something that's online, and you'll think, hey, this is a durable power of attorney. This is good. It's better than nothing. And that might be true. It might be better than nothing. It might avoid the court taking over the affairs of the incapacitated person. But is that good enough to protect your money, yourself, and your family? The answer is likely no. And I want to share with you that not all attorneys will understand the importance of a good, effective, durable power of attorney because they don't help clients who are facing incapacity or long-term care costs or a need to apply for government benefits such as Medicaid. If the attorney who drafted the document doesn't realize why certain provisions need to be placed into that document, they don't know what they don't know. Of course, they wouldn't include certain provisions that an estate planning and elder law attorney, somebody who prepares Medicaid applications, helps protect assets against long-term care, those types of provisions that we would include simply are not well known to an attorney that doesn't practice in the Medicaid area. So I'm not just talking about a generalist. A general practitioner knows a lot about a lot of things, but doesn't have that depth of knowledge. Even estate planning lawyers who don't practice elder law might not be aware of certain provisions, authority that should be included in that document to make sure that that's the best plan to protect assets. So I'll give you some examples in a little while about why a good, effective, durable power is needed. So no secret, make sure you get good legal advice. Don't use a form, don't use Google, unless what you're doing is you're Googling possible law firms for, hey, what do the clients say about them? If you are in a state different than Washington, I recommend that you go to the National Academy of Elder Law Attorneys. Their website is naela.org, and find an attorney who is an elder law attorney. The reason to do that in particular will be to make sure that you have protections in place under your durable power of attorney and your spouses so that you don't end up spending all of your money on long-term care costs. Speaking of long-term care costs, there are many secrets in this area of practice. No secret is that long-term care is expensive. It will run $5,000 a month to $10,000 a month to $15,000 per month. And it doesn't take long for people to run through a lot of money. And the big concern is they're going to run out of money. Another secret, it's not a secret. If it is, I want to disabuse you of this notion. Medicare does not pay for long-term care. You have Medicare to pay for your doctor's appointments, your health, your hospital visits, that sort of thing, but it does not pay for long-term care. What does? Medicaid does. And that's what we're going to be talking about now. For those of you who are close to our office here in Spokane, and given that it is coming up on Thanksgiving, I want to show you this book. And this has all to do about Medicaid secrets. I co-authored this book. If you're interested in getting your own copy of this book, and the price on this book is $49. But during this time of year, during this season of giving, if you stop by our office, 711 West Indiana Avenue in Spokane, and simply bring some food that you want to donate, bring in that food, those cans, boxes, whatever you think would be good to donate during this Thanksgiving holiday, and you will get a free book on Medicaid secrets. So we want to encourage you to come by, bring your can of food or whatever, your bags of food. We'll make sure that they get to the local food bank for you, and you will end up with your own Medicaid Secrets book. One of the things about this book is it's pretty easy to read, but you're not going to be a Medicaid expert after you read it, but it will give you a lot of really good information. So what kind of information will you be getting from the Medicaid book? One of the things that you will learn is what the standards are, how the program works, all of that. But one of the secrets I want to share with you today about the Medicaid benefits program here in Washington State is that it does not need to be an impoverishment program if you are married, because married people are allowed to keep far more money than a single person. For a single person, there's certain exceptions to the rule that you can't give away money. And if you're a single person, please reach out to an elder law attorney who can help you if you're looking at long-term care costs. And that's a subject for a whole different discussion. But the secret for married persons is it doesn't have to be an impoverishment program. And I'm going to show you more about this hugely important fact that if you are married, you do not need to spend down all of your money to qualify a spouse for Medicaid long-term care benefits. You know what most people do, and why I really find it very important to share this information with you, is most people, they don't want to go to a lawyer. Why? Lawyers cost money. So they do what they think that they should do, which is they think that they should, okay, well, I've heard Medicaid, you have to spend down, so I'm going to start spending down. I'm going to spend down money and pay for the care. And then they start getting really concerned because the money is getting low. And then they're saying, well, do I need to sell the house too? And then if you're a couple situation, you know, the one who's the well spouse is going to be saying, well, what's my future going to look like after my spouse dies? Because all of our money is going to pay for the care of the first spouse. And will I be left with nothing? Will I be impoverished? Those are excellent questions to ask. And if you're asking those, or if you know of somebody who's asking those questions, please see an elder law attorney, because as I just said, Medicaid is not an impoverishment program for couples in the state of Washington. And if anybody tells you it is, seek a second opinion. Oh, and by the way, once this couple who didn't get any advice from an attorney, an elder law attorney, does all that, spends all their money, maybe they keep their house and don't sell it. At the end of the day, do you know who gets the house? Not the kids. The state is going to get the house, because there's going to be a lien on the house because no elder law attorney was involved to protect those assets and protect the family members who would have received those assets. So no surprise, most people don't want that outcome. Sadly, many people have that outcome, all because they don't know what they don't know. And that's one of the goals with educating and is to share this information that you can take steps so that you do not become that impoverished person. This is Medicaid. There is a lot that goes on with Medicaid. It's a complex program. The rules aren't well known. Very few lawyers actually have expertise in that area. If you find one, they are a gem, because they will save you literally hundreds of thousands of dollars in the face of long-term care costs. So let me give you an example of what we here at ELG Estate Planning call a Medicaid asset preservation strategy. That's the term that we use when we're working with clients to put a plan into place to make sure that they can keep all the assets that Medicaid's rules say they can keep if you know the rules. So when both spouses are alive, but one is sick, if you seek an elder law attorney with Medicaid experience, you are going to learn about how to qualify the sick spouse for Medicaid, yet the well spouse gets to keep most, if not all, of their money, all of their assets. So here's the example. let's take Joan and John, and they're in their 70s. They have an estate that's worth $1 million. $1 million, which consists of a house that's worth $500,000, and then they have $500,000 in their bank and their investment accounts. Now, in this example, Joan, the wife, has advanced dementia. John has been taking care of her for years, which is very common that the spouse without the dementia will be that person to care for their spouse and take care of them as long as they can, because everybody wants to stay in their home. Nobody wants to move from their home to a facility. And John's doing his best. And for years, he's taken care of Joan. But at some point in time, what happens? Often the caregiver spouse will get sick. They could die, but let's say they are just tired. They've been taking care of the person for so long. They're in their 70s as well. Maybe they have some health conditions, and they can't take care of their spouse anymore. And the family knows this. Everybody knows this. And it's just reached that point where John says, I can't take care of Joan any longer. I need to find a care facility. How is he going to do that? Well, one of the gems, one of the secrets I want you to know about, he doesn't have to do that on his own. There are people who are called aging care managers, and they will help John find the right placement for Joan. So keep that in mind, that you're not on your own. There are so many resources that can help you find the right care, the right placement. So John does. With help, he finds the right place for Joan. It's going to be an adult family home, and that adult family home will have, usually it has about 6 residents. There's some that are a little bit different that might have more, but it's a nice homey setting, and Joan likes it there. And John can finally feel that weight off of his shoulders, at least when it comes to care. But what about the costs? Because the costs can't be overlooked. So let's talk about costs, and let's talk about Medicaid asset preservation strategies. So the Medicaid program, if you look at that and you've got $1 million, you're going to say, I don't qualify for Medicaid. That's way too much money. And you would be right. But that's not where the analysis ends. Let's dig in deeper. Of their $1 million, $500,000 is in a house. Under Medicaid's rules, that house doesn't count against this couple for Medicaid eligibility because John lives in that house. So out of the $1 million estate, $500,000 goes off the table. That is a non-countable resource. So let's talk about the other $500,000, which counts. That is money in the bank, IRAs, etc. What do we do with that? Well, let's get into the care piece a little bit more. Practically speaking, when somebody moves into an adult family home or assisted living facility, that facility will have what's called a private pay requirement. Not all facilities do. Many good facilities will say, no, we'll take Medicaid right away. Some will say we'll take Medicaid never. Some will say we'll take Medicaid after 2 or 3 years. Some will say a year or 6 months. One of the reasons that you want to be working with an attorney and an aging care manager is that it is advantageous to negotiate for you the shortest private pay period possible. So in this situation, John has found the adult family home that will do memory care. They have a 1-year private pay period, and the cost at this home is $8,000 a month. So doing the math, John is going to need to go through $96,000 to pay for Joan's care for that 1 year, not because of Medicaid, but because the facility requires it before the facility will accept Medicaid. So be aware of that. Medicaid isn't necessarily accepted right away. So you want to be doing planning in advance. That's one of the reasons to seek out an estate planning and elder law attorney years in advance of actually needing care, Why? You want to have the good estate planning and documents in place before somebody loses capacity. Fortunately, John and Joan did that. So even though Joan has dementia now and doesn't have legal capacity, that doesn't mean that John can't take the steps he needs to protect his assets and make sure Joan has good care. And if it sounds like I'm getting into a lot of details with Medicaid asset preservation strategies, I apologize. I am, because it is a very fact detail oriented process. So that's why I'm giving an example. So let me move on here with this example. And obviously in this case, they don't have long-term care insurance. All they have is their assets, and John's going to have to go through about $100,000 before Medicaid will be accepted by the facility. And that's what he does. So before that 1-year private pay period is up, John is working with his elder law attorney. Now, out of $500,000, which is countable, he's going to take $100,000, pay for the care facility for that 1 year. He has to do that, not because of Medicaid, but because of the care facility. He's got $400,000. And if you ask any attorney, is $400,000, am I eligible for Medicaid? The answer is going to be no, you're not. Don't let the analysis stop there, because we have tools. The secret is that we have tools in place that allow John to keep all of that $400,000, all of that money. How does he do that? In the state of Washington, for this type of care, the state of Washington is going to say, John, you can keep about $60,000. It goes up every year, but I'm just going to use $60,000 as a round number. The ill spouse, the person on Medicaid, she only gets to keep $2,000. But John needs to keep $60,000. He's got $400,000. You're saying, what do we do with that $340,000? Too much money. Medicaid allows John to purchase a Medicaid compliant annuity through which he takes what is a countable resource, his bank account, $340,000 too much. He buys a $340,000 Medicaid compliant annuity in his own name. And in the state of Washington, our rules will say that that is going to pay back to him month after month over a 5-year or 60-month period. So if he puts $340,000 into that annuity, it's going to come back to him every month, $5,667 a month. He will get all of his money back. He did not need to spend down his money. His wife qualifies for Medicaid. He gets to keep all of that $400,000. He simply needed to convert it from one form to another, and the other being the Medicaid compliant annuity, which pays back to him. He gets that money back. He will not be impoverished because he went to an attorney, an elder law attorney, who understood Medicaid's rules and helped him keep all of his money. That is a gem that I want you to keep in mind, that saves hundreds of thousands of dollars, and it makes sure that John or whomever is the well spouse will not be left impoverished. I'm going to keep going, even though I think that was one of the most important things that I wanted to convey to you today. I don't want anybody to think that they have to lose their house because they're on Medicaid. A couple should never lose their house. They might lose their house if they don't go to an elder law attorney. Think back to when I was describing what couples typically do, which is spend down their money, spend down their money, spend down their money till they have only that $60,000 left. And then one goes on Medicaid, the other's living in the house. What happens then if they haven't seen an elder law attorney? What happens is at the end of the day, the state is going to get the house, at least to the extent of Medicaid benefits paid for the ill spouse. The state won't enforce that lien until the second spouse dies, but the state will still get the house and not the kids of the couple, which is a terrible result, especially terrible because it could have been 100% avoided through good legal counsel. So recall I said that in our example, John and Joan had good estate planning documents. They had good, effective, durable powers of attorney, and they were smart enough to use an elder law attorney who knew about Medicaid. They are not going to lose their house. Not only are they going to keep all of their money, they're not going to lose their house. How does an elder law attorney protect the house for this couple? Well, it's through that most important legal document, the durable power of attorney. So when Joan had capacity to do so, she signed a good, effective, durable power of attorney, appointing John as her attorney in fact. That means her POA. That means the person that has legal authority to act on her behalf. When Joan goes on Medicaid, what is John going to do with the help of his attorney? He is going to sign a quitclaim deed conveying Joan's interest in their house to John. He does that through the power granted to him in Joan's power of attorney. Without it, Joan can't sign, and we can't convey the house to John, to the well spouse. In addition, to make sure there's no argument that Joan has any property left on her death, we're going to make sure that all bank accounts are in John's name, and we are going to have John sign a separate property agreement where Joan conveys all of her property to John. And she does that through her power of attorney. So John signs on her behalf. Even though Joan lacks capacity, we're able to do this because we have the good, effective, durable power of attorney. As a result, this couple got to keep all of the money that wasn't required to be paid to the facility on that private pay period, and the state gets nothing. And when Joan is on Medicaid, her income only goes to pay Medicaid. None of John's income in the state of Washington will be required to pay for Joan's care, so John is not impoverished. That is so important. That is a secret. It shouldn't be a secret. Please share this information if you know of anybody who might benefit from it. And it is definitely a gem that saves hundreds of thousands of dollars. You can tell I get excited when I'm talking about Medicaid strategies because it is so not well known that it's an area where I feel we can make a big impact in helping people. Other secrets about estate planning documents. And again, I'm going to keep my focus a little bit on long-term care costs, but not necessarily just long-term care costs. A will is a very important estate planning document, especially in the state of Washington, if you are worried about long-term care costs. Why is that? Because in the state of Washington, when the first spouse dies, if their will contains a special kind of trust for the surviving spouse, we call it an asset protection supplemental needs trust. If the spouse who is dying and dies has a will with that special trust in it, then their assets will all go to the trust for their surviving spouse. A probate will be required for that to occur, but that is the way that we can take the deceased spouse's assets and put them in a trust for the surviving spouse. Now, why are we putting it in a trust for the surviving spouse? Well, imagine Joan. If John were to die before Joan, and John has all the couple's assets, but Joan's on Medicaid, but John dies first because he has a heart condition, and Joan is still doing okay in the memory care facility with her Alzheimer's. He dies first. All the assets that are in his name will fund the trust for Joan, and any assets in that trust aren't owned by Joan. And what that means is Medicaid doesn't count them as hers, and her benefits will continue uninterrupted, will not go to her care costs. And then when she dies, those assets will be distributed out to their children or to whomever they wanted to receive them. Again, the state gets nothing. This result of protecting assets for the surviving spouse against long-term care costs and to maintain Medicaid eligibility for long-term care can only be achieved through a will, at least in the state of Washington. That's our rules. A secret that maybe sometimes especially trust lawyers, overlook and don't share with you is that a revocable living trust will not accomplish that result. If there is a revocable living trust, and even if it says it has a supplemental needs trust in it for the surviving spouse, the state of Washington will not honor that as asset protection. In other words, with a revocable living trust, if the spouse dies and they say, I want my spouse who's living and who needs care to be able to receive these assets and be eligible for care, they will not. All of those assets that are countable assets will need to be spent down. So one of the things about revocable living trusts is why they are so popular is that they will avoid probate if they're done right. But in the state of Washington, if you take that route versus taking a will with this trust in it, then you're not going to protect assets for your spouse once you're gone against long-term care costs. So yes, there will need to be a probate, but in the situation I described of John and Joan, you're protecting half, if not all, of the couple's assets because you have a will and you're maintaining Medicaid eligibility. You cannot do that in Washington with a revocable living trust. I mentioned probate, and one of the secrets I think I want you to know about is that probate can be a very good thing. And that is not the message that you'll hear commonly when people are talking about probate. People say avoid probate, have a trust, do other things. And, depending on your particular situation, that might be what's right for you. Perhaps you have long-term care insurance. Perhaps you have, millions of dollars of assets. There's all sorts of reasons that having, avoiding probate might be right for you. But I don't expect anyone who's not an estate planning and elder law attorney to know that for themselves. Rely on your attorney and ask these questions of them. So continuing on with why a will and that necessary probate is a good thing is that it allows the deceased spouse to protect their assets. When they're gone, whatever they had is going to go into the trust. Anything in the trust is not going to count against that surviving spouse for Medicaid eligibility. So let's just take a situation where, the couple, maybe nobody's on Medicaid yet, but they're worried about Medicaid, or they're worried about long-term care costs. And they've got $1 million estate. Let's say that this was even before John and Joan got Joan on Medicaid. And John dies first. What this will with asset protection allows is at least half. So John's half, $500,000, goes into a trust for Joan. Maybe all the bank accounts go into a trust for Joan. And Joan needs Medicaid because, before John was living in the house with her, taking care of her. Now he's gone. She needs to move to a care facility. That money doesn't have to be used for Medicaid eligibility. In other words, you don't have to apply for Medicaid, so it can satisfy the private pay period. But whatever is in that trust is not going to interfere with Medicaid. Very important, because through what is a probate, which let's say a probate might cost $5,000, maybe even $10,000. This couple protected $500,000. And if they had advanced knowledge that one of them is going to be dying, in Washington, we often use separate property agreements to put all the assets that can be put into the name of the dying spouse in their name. Sounds counterintuitive, but the reason that we do that is if all of the assets of the couple, the house and the bank accounts, all are owned by the spouse who will be dying, $1 million, then all of those assets will funnel through the probate, through the will, through the probate, into the trust for the surviving spouse. So under Medicaid's perspective, yeah, there's a trust with $1 million in it, but they ignore it. They look at what assets are left in the name of the surviving spouse, which are nothing or relatively nothing. The surviving spouse qualifies for Medicaid, despite the fact there's $1 million in the bank that benefits them. And that money then, after the surviving spouse passes, will then go down to the children or to whomever they wanted to receive it. So a probate can be a very, very good thing. So don't just assume avoid probate, that's the right thing. Not necessarily. You might be, making a $500,000 to a $1 million mistake. Go see an attorney who can help guide you on that. All right. Got a few questions. I think I have time. I want to follow up, first of all, about estate taxes, estate tax secrets, and then I'll go in and answer questions. That we're talking about Washington State. Estate taxes here are not just for the very wealthy with multiple millions of dollars. Consider how housing prices have gone up, and the small house that used to be worth $100,000 is worth $1 million, etc. In Washington State, there is what's called a credit exclusion amount, estate tax credit exclusion amount. And what that means is that's the amount of money that a person can pass on their death without their estate having to pay any estate taxes on it. And in Washington, it's $2.193 million. The federal level is much higher. Currently in 2023, the level for the federal exclusion amount is $12.92 million. That is less of a concern unless the person is very wealthy. But for a person who has a level of, closer to 2 million or 3 million, they should be concerned about the Washington estate tax. There are many ways to avoid this tax other than don't be a Washington resident, be an Idaho resident, Colorado, etc. There's a lot of ways that you can still be a Washington resident and avoid the estate tax. If you're married, and whether you have a will or whether you have a trust, make sure that within those documents is something that we call it's called a credit shelter trust, a bypass trust. Different terms are used, but what it means is the deceased spouse's $2.193 million is going to go into that trust so that we can take advantage of their credit exclusion amount. If that is not done, and if instead that money just flowed outright to the surviving spouse, let's say the couple has a $4 million estate. And if they don't use that trust to capture the credit exclusion of the deceased spouse and avoid estate tax on that amount, if instead it goes outright and the surviving spouse has $4 million, when that person dies, if they do nothing else, there's going to be an estate tax of a couple $100,000 or so, all of which can be easily avoided. Washington also has other ways of avoiding the estate tax. We don't have any gift tax, so giving away assets during lifetime, especially after one spouse has died, is a really viable strategy. Of course, giving to charity under the tax code avoids any type of estate taxes. There's all sorts of ways. If you have too much money, meaning beyond the estate tax limit, see an attorney. They will help you with a plan to avoid paying unnecessary estate taxes. All right, so let me take a look at some of the questions and answers here. So this is from a single person, and it says, is there a way for a single person to keep their funds to pass on to their children if they need to use Medicaid for long-term care? The answer is yes, but it depends on the circumstances. So Medicaid asset preservation strategies for single people, it's a little bit more difficult because we don't have the spousal resource allowance of $60,000 or more, and we typically don't use the Medicaid compliant annuity. So what do we have left? Sometimes single people will do a Medicaid trust 5 years in advance of need. So they're really concerned about passing assets to their kids. So they, 5 years before they would need care, give them away either outright or to a trust for their kids. The thing is, if you give assets away, you have to give them away. You cannot retain any benefit. So it's really potentially impoverishing yourself to take advantage of Medicaid's 5-year look back and gift beyond that period of time. So other strategies that exist, Medicaid has an exemption. You can give away assets to your disabled child, and the disability doesn't need to be like a cognitive disability. It could be maybe your 50-year-old son has a back injury and they're on SSDI. You can give away assets, no penalty. There's other ways to give away money to a caregiver child. Those rules are really strict, so you'll definitely want to work with a lawyer. So there are ways to protect money. We also at ELG Estate Planning often will incur an intentional period of ineligibility, giving away money during the 5 years, and then apply for Medicaid, because the math simply works out that it makes sense to do so and it doesn't jeopardize the person's care. There's some programs that Medicaid has in the state of Washington that do not have a penalty period associated with giving away money. The CFC, or Community First Choice program, is one of those. There's other programs called MAGI that if the person is under the age of 65 and they need skilled nursing care and they're not on Medicare, there's no resource limit. So I think hopefully what you're getting from this is there's a lot of rules, and maybe one of those rules fits your situation and will help you keep your money. You won't know about it until you seek the help of an elder law attorney who knows Medicaid. Another question is, does the Washington CARES program have any play here? The Washington CARES program is a newer program. It provides a limited long-term care benefit. I think it's around $36,000, and it's an employment program now. By that I mean wages. From your wages, money is deducted, and the whole idea is to put into place an insurance-based program as opposed to a needs-based program. I think we're the first in the United States to implement such a program. I think it's a great idea, but it is very ineffective now, completely ineffective if you are not employed or you're a certain age. And if you are younger, basically the benefits and the time frame for, covering long-term care is going to have to increase. But in terms of, whether or not it's a good policy to start with, absolutely. It really needs to be employed on a much larger basis, though, however. Another question, how does a HELOC, which is a home equity line of credit, affect Medicaid eligibility for a couple? It doesn't, unless the HELOC has been exercised and the money has been taken out. If the money has been taken out, put it back in. Just like one of the strategies that people have too much money, they still have a mortgage on the house, take that money, pay off the mortgage, because remember, the house and all of its equity is non-countable. So putting money into the house, improving the house, even sometimes it seems kind of paradoxical, buying up a new house might make sense. Why? Well, maybe it's a better house and you want the care delivered in the house. So, but in answer to your question, a HELOC itself, as long as there's not money from the HELOC in your bank, doesn't impact Medicaid eligibility. Does putting a home in an irrevocable trust hedge against expenses of long-term care? Getting back to my earlier answer about what can a single person do, they can put their house in a trust or give away all their assets 5 years before. Let's talk about the house. In Washington, in particular, we want to be very conservative. We don't want to retain any beneficial interest to anything that's put into a trust. So if you put your house into an irrevocable trust 5 years before you apply for Medicaid, remember, you can't be the grantor. You can't be the trustee of the trust, meaning you can't manage it, and you can't be the beneficiary. Well, it's your house. So how are you going to continue to live there? The most conservative and recommended approach we have is you pay rent to the trustee. It's not your house. You're not the beneficiary. Somebody else is. So it's an income producing asset for somebody else. And if you want to continue to live there, you pay rent on your house. And frankly, that may or may not work for you. It has for some of our clients, but some clients say that doesn't make any sense and they're not going to do that. keep in mind that the house is a non-countable resource. And so there are other strategies that we have that if you own a house and if you need Medicaid right away and you're single, we might be doing a different strategy, and the house and your equity is a big tool that we'll want to use. So putting your house into an irrevocable trust for Medicaid typically does not work unless you are okay with paying rent because you're not a beneficiary. Okay, we are at the top of the hour now, so I'm going to wrap this up. If you take a look in the webinar chat, you'll see how to get a hold of us. And as a reminder, if you are local and you want to stop by, oops, I think you can see this, and get this book, $49 at no charge, bring in some food for the local food bank, and we'll take it there for you. Please come by. We're happy to give that to you as our gift today. So thank you, everybody, for being with me today. I hope you got some really good information. Any other questions that you might have, please feel free to reach out to us, ELG Estate Planning. Our phone number is 509-468-0551. We're at elgwa.com. Again, thanks so much for being with me here today. I appreciate it. Take care now.